Youth criminal justice, extrajudicial measures, extrajudicial sanctions. What happens when a youth commits a less serious offense that does not involve violence, or that the youth does not have a prior criminal record? Rather than what would happen in a regular criminal offense, the youth can either be given informal punishment, called extrajudicial measures, or a more formal punishment, called extrajudicial sanctions. Informal extrajudicial measures do not result in any charges being laid. Extrajudicial measures include police giving the youth a warning, talking to the youth and explaining the legal consequences of the behavior. Or, the police can caution the youth. This involves a formal written warning, a letter to the parent or guardian. The letter would say what the youth did, and that the parent needs to come to the police station to speak with a senior officer. Last, the police can refer the youth to a community organization or program. These can involve recreational programs, counseling, child welfare agencies, youth justice committees, and where appropriate, mental health agencies. The youth must have been given full information by the police about these programs, and they must voluntarily accept the program. If the informal options are not appropriate, or the youth does not voluntarily accept the last option, police can lay charges, and the youth can be subject to the more formal extrajudicial sanctions. Extrajudicial sanctions, or EJS, are formal, and the youth must go to court before a Crown prosecutor and judge or justice of the peace. The Crown can choose to reprimand the youth in open court, or request that extrajudicial sanctions are imposed, which are commonly referred to as diversion. Formal extrajudicial sanctions commonly includes mandatory supervision by a parent or guardian, and the youth must complete a number of conditions. In order for the youth to be in the extrajudicial sanction stream, there are several conditions that need to be met. Examples of EJS include written apology to victims, community service to nonprofit organizations or government agencies, restitution, returning property to the victim, write an essay about their experience and lessons learned, donation to registered charity, attendance in community counseling or intervention program. If the case isn't closed, the youth will have to come back to court and report to the court the progress of the program or conditions that they are ordered to do. Once completed, the charges will be stayed and the case is finished. If the youth does not complete the conditions or the program, the Crown can either give them more time or proceed with formal prosecution, which can result in a criminal record or more serious punishments. What if the youth commits another offense? Any past EJS will come up in sentencing. Any past informal EJM will not come up in sentencing. EJS will remain on the youth's record for 2 years. Police caution will be in the system so they know that there have been prior incidents. Remember, the youth has the right to counsel. If they cannot afford one, there will be one appointed, or a duty counsel lawyer will assist. The youth must voluntarily agree to EJM or EJS. They must accept responsibility for their actions, or else this option is not available to them, and they will go through the regular criminal prosecution.